Good evening, and it's welcome from Andy, Peter and Kevin Ball. This is the Earth News Rebels show on criticalmassradio.co.uk. Visit the Rebels on the Earth News, visit the Rebels, on freethinkingvoice.org, freethinkingvoice.tv, or email the Rebels at the Earth News Rebels show at freethinkingvoice.tv, and we'd be glad to have you on the show as a guest. Before we play the first song, a very, very, very happy Saturday tomorrow for the conference in Manchester at the Britannia Hotel for the Critical Mass Radio show hosts. Have a safe journey, enjoy your evening, enjoy your day tomorrow. We'll be thinking of you. We're just sorry that we couldn't be there with you. But for now, on with the show. After the next record, we have Julie Haines. Oh, good evening, ladies and gentlemen. I hope I don't sound like that when I get older, because that sounded awful, didn't it? Are you with us tonight, Kev? Sorry about all these...
I am. It sounded like, I don't know what that sounded like, but it was awful.
It did, yeah. I think I refreshed my page during the song and that happened. So, welcome, Kev, tonight. It's our show, the Earth Needs Rebels, Kevin Bull and Andy Peacher. Tonight we have Julie Haines here back again. Sounds like she's dropping a cup of tea already. Welcome, Julie. This is the time you talk now, or unmute.
Hi, Julie.
You carry on talking, Kev.
I'll carry on talking. We did a full show last time on CMR with Julie, and she took us through a lot of the domestic law side of things and what's happening in the family courts, and that was really interesting. But we didn't have enough time to cover everything we wanted to do during that time. I revealed a few of the things that were going off, and also one of the cases with Slovakia, with a Slovakian grandmother, which was also interesting as well.
We have Kevin Ball, Andy Peacher, and our lovely friend Julie Haines.
Hi there.
Hello, Julie.
Hi, Julie.
You should make promises you might not be able to keep, really.
I don't know that microphone, but we've got there in the end, haven't we?
Well, part of the problem was I didn't actually have it here in front of me, and it had disappeared somewhere else. And I didn't realise I needed to kind of talk into that. And then Tim arrived. He said, "You don't have a microphone in front of you." And then when we did get it plugged in and everything, it wouldn't work, so we had to reboot. So that's basically it.
We can hear you loud and clear now, Julie. Anyway,
Okay.
It was good last time on CMR. We did covered quite a lot, didn't we? You know, the domestic side of things and the court process, and of course the case you've recently won, which was all very interesting. But we really ran out of time, I think, to finish off what we were trying to work through and move into other areas, if I remember.
Yeah. I hope you can remember where we're up to, because I definitely can't, because my notepad has disappeared.
All right, I'll leave you in, Julie. We got to the point where we were looking at the grandmother's situation in the case you've won, where it effectively starts to make a bit of case law in favour of grandmothers in view of her rights being considered around the child in the case. And I don't know whether you want to pick up on that end of it so that people who come in fresh today will understand about that particular case, why that was important.
Yes, indeed. It didn't just make any case law about grandmothers, grandparents. It made some case law about the lack of reasons in making a placement order and dispensing with parental consent. It's the dispensation of parental consent that is the key thing, I think. It's a really big thing. Basically, when the court decides the placement order is made, a placement order to place the child with adopters by the local authority or the agency, they have to sort of make absolutely certain that the parents can't object to it. And it just sort of happens as an automatic thing. Oh, well, we're making a placement order. Okay, we'll make the care order. Oh, yes, and you can't object to it either. And it just seemed to be a little bit sort of formulaic, really, and it just seems to have to happen automatically. But this was specifically about the lack of reasons. The local authority brought case law to deal with the lack of reasons, but the Lord Justices were all in agreement, all three of them, which was wonderful, because I expected one to dissent, but no, we got all three Lord Justices on board that you need to have the
You're listening to the Earth Needs Rebels show with Andy Peacher and Kevin Bull. Join the rebels at freethinkingvoice.org.
The higher you build your barriers, the taller I become. The farther you take my rights away, the faster I will run. Can deny me. You can decide to turn your face away. No matter, 'cause there's something inside so strong. I know that I can make it. Though you're doing me wrong, so wrong. You thought that my pride was gone. Oh no, there's something inside so strong. Oh, something inside so strong.
Yeah, maybe I shouldn't have said that too quickly, Kevin. I think we've brought Julie back on now. Have you got audio, Kev?
I have, but Julie's just dropped.
Yeah, no, it must be Julie. So don't know them, mate.
I think we're okay. I think the problem is that Julie's end on her Skype, and we'll try and bring her back in. But probably the best thing to do is, whilst you keep trying to bring Julie in, we can continue with the show anyway.
Sure.
Andy, on a slightly different format. We can cover it on law anyway, in where we're going on some of the events before the English courts and that, and possibly international law as well, if we bring that into it. We were going to come into international law today. That was the concept of moving out of the domestic law to give an idea to parents as to how complex it is and how difficult it is. It isn't anything like what you'd think to deal with international law, and often parents flee and then they find themselves losing their children because they've fled without doing a full legal check to see whether or not their children will be effectively recovered under law. And there are certain things that people have to seriously consider, as well as the health, before leaving the jurisdiction, and they have to really get a complete legal check. And some of the reasons for this are that a foreign court, once it's the English Social Services file with that court in the requested jurisdiction, have to really react in a certain way to orders from an English court. You've got the comity of the courts, and this means that for it to work between two countries, the comity of the courts means that one court, say, for instance, it might be Ireland that someone's fled to. It's quite common for people to flee to Ireland. Then the Irish court has to look at English court orders in a certain way under international law, that if those orders are valid and served and everything's appropriate, then they have to recognise those orders. And if those orders mean that England have seized rights of custody over a child, then that will normally accept under exceptional circumstances, if it's a Hague Convention case, probably Article 13 or Article 20, where there are rights in the foreign jurisdiction considered constitutional rights, etc. It will normally result in the child being returned to England. When the child's returned to England, with or without parent, the end result then is the English court usually behave quite naughtily, and the case gets a lot worse because they're not happy that someone's fled the jurisdiction. So you can understand that it's important that before anyone flees the jurisdiction, they make sure they're not going to just automatically be recovered, and they consider where they're going to as well. So some of the things that can stop parents fleeing a jurisdiction without being recovered are very straightforward things, really. One of them is if it was only one half of a party, i.e. one of the parents with the children, even if it was estranged, and the other parent remained in the jurisdiction and they fled, then that parent could be either used by social services as an additional party to the case to recover the child and back to the English jurisdiction for then everything to fall under domestic law for any marital issues, rights around the child to be sorted out. In that situation, that would be, if there was no contact order, that would be where a father could apply under the Hague or as part of the case, as has been done before, or be adjoined to the case if social services are already pursuing. But even if there's no court orders around child proceedings, if there is a contact order in place or any order around the child under the Court of England, then at some point in that order you'll find a section that effectively doesn't allow the child to leave the jurisdiction for more than, I think it's 28 or 30 days, depending on the order. It can be varied by the judge, but it's fairly typical to be 28, 30 days. And that is the Court of England exercising its rights of custody over the child through the court order. And if you imagine if you've got a husband and wife who are estranged and then there's a contact order, the original concept of that is to prevent one of the parties disappearing to the other side of the world with a child, preventing the other party having any contact with the child. So the original concept of putting this on contact orders was to protect the child, protect both parties, really. But increasingly it's been used by social services as one of the methods to get children back, and then when they get them back, they finish up either being placed in foster care, placed with another party, or they finish up being forcibly adopted. So it isn't quite what it was originally intended to do. Now,
Hello.
Hello, Julie.
Yes, gosh.
I'm glad to have you back. I've been wading through a section on this. I'll just finish up a little bit and explain a little bit of the international law, Julie, on how children are recovered from foreign jurisdictions when rights of custody exist. For instance, the first version was with a father who could apply under the Hague or become party to a case if social services are involved in order to recover a child from a foreign jurisdiction under international law based on rights of custody. The second version I'm just going through now, Julie, if you want to join in with me, is where there are contact orders existing between, shall we say, estranged parties, a couple who's split up and there's a contact order in place, or any type of UK order that carries the normal rights of custody clause in it, shall we say, for the Court of England to protect the parties and the child, which usually, I think if I'm right, Julie, it's 28 or 30 days. You can't take the child out of the country on a contact order. Is that currently about the time on that?
Yes, about 4 weeks.
About 4 weeks. What actually happens in that situation, why that's important in international law, is that because that's a Court of England order, if someone flees to another jurisdiction and they haven't done all the legal checks to make sure they can leave the country without being recovered, then when they get to the foreign jurisdiction, all England needs to do then is the party concerned who's got the contact order. If that person is wanting to recover their child, they would really only need to file under the Hague Convention or indeed B2R to recover that child from the requested jurisdiction, hypothetically, let's say Ireland, and then they would go before the Irish courts for basically a situation of that order being enforced in the jurisdiction being recognised. And upon doing that, working through international law, providing everything's been legally done correctly, i.e. the order has to be served originally, everything has to fall into place in the normal legal process under English law. And if that has taken place and all the evidence is before the foreign court, it is almost unheard of for a foreign court not to return that child. And the grounds for that on those type of orders would be wrongful retention rather than wrongful removal, because the wrongful change in law didn't happen until the end of the 28 or 30 days that the
Are you still here, Julie?
I'm here, yes.
God knows what's going on tonight.
Technology really does worry me for this very reason.
No, it's Skype and hello, Kev. It is Skype, and I firmly believe. I firmly believe it might even be my PC's problem tonight. But then I don't see my green light of Skype going out, but I do lose connection. So does Kev. So did you. So I don't know.
I think it could be random, Andy. I'll tell you why. Because we were losing Julie, and as far as mine's concerned, that was me dropping out. So I think it's general problems with Skype tonight.
Yeah, also, there seems to be a fish in the background. Has anybody got the chat room on? If so, there is a mute button.
I've got no audio on my chat room.
I can hear the water, pinging.
Nope, it's not mine.
Okay, not to worry then. I mean, I just didn't want it to come out on audio later, but I haven't got any Internet Explorer open. Carry on then, Kev.
Okay, I'm just checking if there's any other way we can get the audio transference on the chat before we continue. Which I don't think we can. No, I can't explain that. Right, I don't. Well, what did you hear me up to, Andy, Julie?
It was up to wrongful retention.
Right, great. I don't really agree with me on that, Julie, picking up on that, just on a light outline for people, that it's very important before considering leaving the jurisdiction that you have a full legal check if you go into another country, because it's hopeless to leave the jurisdiction with your children and then find out later when you get to the other jurisdiction, because of a document that's in force, like a contact order, that effectively your children are going to be taken back to the Court of England under the Hague Convention or B2R once that order is enforced in the requested jurisdiction, because it's almost automatic, except under exceptional circumstances for that to happen, Julie.
Yes, indeed. I think actually that a lot of people don't give it any thought, because they might just think, oh, well, we're just going to go and see a relative for 6 weeks or whatever it is. I think these days we have to be really, really careful with regards to anything to do with legality in any area of life, actually, because you think, oh, I'm just taking my child out, not sure entirely when I'm going to be back, but I will be back at some point. And then the next thing you know, you've got somebody knocking on your door, and you're possibly being carted off, or the child's being carted off. And I mean, I don't know if that's actually happened to anybody in terms of they didn't realise, but and it wasn't deliberate. But at the end of the day, I just think you've got to be really, really careful and read absolutely everything. It can land you in a lot of trouble.
Yeah, and it's really sad as well, because I know you see the other side of this, Julie, so it's good that we're both on to do this. I mean, Katie works in international law. I'm not as involved these days. But what actually happens when our family, most of the families we pick up on have already arrived in the jurisdiction, really, and therefore they've not entered into any kind of legal checks with us or anyone else, and we then are confronted with a situation. They're in trouble, they're in an awful mess. England is filed or is making approaches to be it the HSE in Ireland or the social services of another country. And what tends to happen is that England put the fear of God into any other country's social services and state with you know where I'm going here, Julie.
I do, definitely.
It's like reading the post after you describe the stories that you get in the documents. They're unbelievable, I'm telling you. I suppose some of them could be.
You're back.
Hi.
You're back.
Hi, we'll try.
Broxtowe case.
Yeah, Rockstow case. I think it may be your PC this time, Andy, because it's dropped out of the show. Right, yeah, the Broxtowe case, which was a very famous case from, I think it was 1989. I do know one of the survivors of the case who is now adult, and unfortunately, sadly, it's going to get complex if we go right into it. But what the Broxtowe case was where Nottinghamshire County Council got into an awful mess when they started to make allegations of the local community of witchcraft and satanic base to all sexual abuse, and they really went big time on this in about 1988, 1989. And as a result of this, they pushed it and pushed it and pushed it on a number of cases. And I was actually working in the community in Broxtowe at the time. It's an outer city deprived area. It really has a lot of problems. And I was working in the community. I can remember it got so bad that local residents in the area were planning to burn down the social services building. It really was getting naughty with these outrageous allegations. And the kind of allegations, if anyone wants to read about the Broxtowe case, it's actually published in the US. Just search Broxtowe case, or the other name for it is the Jet Report, which the Jet Report effectively was where it resulted in the Nottinghamshire County Council really wanting gagging orders to stop the rest of the world talking about what had happened. And in that case, even the Nottinghamshire Police Force refused to cooperate with Nottinghamshire County Council because the stories that they were claiming were happening of the local vicar and people flying around on broomsticks got so ridiculous. Jesus' hand plate and things. There was all kinds of wacky stuff going out. But social services convinced a number of other departments that this was happening, believe it or not.
Yeah, sorry about this, ladies and gentlemen. I hate my PC tonight.com. Let's just play a bit of music and we'll see what happens. And we'll do a fix. There will be a fix to this.
Back in again now.
Oh.
We're having a few problems with the Skype here, Andy.
Yeah, the trouble is it's not. I'm looking at my green button. Although I'm losing audio and I'm getting clicked off the studio, I'm not actually losing my Skype on this PC like I normally do when it's playing up. The only thing I could suggest, it'll take too long. That's the only trouble. You've got, if you log into the control panel and do it from your end, but by the time you've
we're going to lose the show, aren't we?
Yeah. Might just put up with it for today.
We'll have to try and see how long we can last this day or for it.
I'm trying to fix the other issue for later on, but the more I'm interacting this time, the less I can interact.
Okay, let me carry on with where we got to.
Sure.
I'll explain where I'm going in a minute, Julie, to bring you back in. The Broxtowe case resulted in some pretty crazy stuff as a time going off. It was about the time that wardship rules were changed as well, because wardship orders were used in the Broxtowe case quite inappropriately. And when Section 100 around wardship was changed dramatically in the 1989 Children's Act, all these changes came about at that time, so that effectively wardship orders couldn't really be made unless no other order could be made. I don't know whether you want to enlighten anything on that, June.
On the case itself.
Not necessarily. I'm referring to the Section 100 wardship orders, which changed in 1989 to under the 1989 Act. They could no longer be made if any other order could be made instead of the wardship order.
Yeah, no, that's absolutely true. Although it has to be said that there have been a few recent wardship orders in the High Court fairly recently, if I'm not mistaken. But I don't really want to be able to say who they relate to in actual fact. But wardship was an old thing which happened when parents got divorced. I mean, my mother nearly had me made a ward of court. I don't know why particularly, but she said she had considered that. And it kind of usually related to divorce more than anything, but yes, no, it certainly has been used recently, as recently as early this year. So,
yes.
I mean, I don't want to say who it is.
Yeah, obviously wardship orders are very common even today, but the grounds they're made on today is slightly different. That's what I'm saying, Julie. Prior to 1989, it was very easy to get a wardship order, and they were used in jurisdiction almost like a care order or a care order.
Yes.
And social services were taking them so frequently. The Brockton case highlighted this, as well as a few other cases, and they changed how wardship orders could be used, because it's quite draconian to use a wardship order, and changed it so that they could only then, under Section 100, make a wardship order. Basically, if no other order could be made, is the point I was making. But going beyond that, where this comes in is what happens if someone leaves the jurisdiction is wardship orders are used frequently by the Court of England then in order to get the return of children. Now, you might think that, I know people won't understand the international element. It's nothing to do with what's happened with children, whether they've suffered harm or not. It has nothing to do with it at all. The merits of the case are irrelevant to an international court. The only decision an international court is making is to decide under certain, if it's Hague Convention Article 3, they're deciding which country, which residence of the child is, which country effectively has people holding rights of custody, and then from that they can decide which country's courts should have jurisdiction. It's a bit more complicated than that, but keeping it simple, that is the basis of what's going off in the first part of the Hague Convention, or B2R case. And the concept of this, people think it's all about if the child is harmed, of course it's not like domestic law at all. And once that has been decided which court has jurisdiction, if it is the child's been taken from England, if it decide it is the requesting your jurisdiction being in England, then that child is returned to England, except after consideration of certain defences. The defences in the Hague Convention, for instance, come under Article 13 mainly, and then we've got Article 20 in certain cases, which is mainly about adoption and matters like that, which could come up if they were in a jurisdiction, as Ireland was originally, where forced adoption is not permissible in Ireland, and the Constitution of Ireland, the rights to that, offer a higher level of protection than the child would have in the UK, and even higher than the European law. So then an Article 20 case would be possible in that type of jurisdiction. But other than that, it's generally Article 13, which is about looking at what threats there are to the child if the child is returned to the requesting jurisdiction. Now, people would think, well, we could argue about the risk of a partner or something like that. That's invariably doesn't work. The types of non-return situations of Article 13 would be merely about returning a child to the virtual war zone today, would be the type of level where a foreign court would refuse on the basis of an Article 13 defence, because the laws move over that way. But the one big thing that is still current in Ireland, and that may be current in other jurisdictions, but for the law, is if siblings. If there is siblings and only one child is subject to proceedings in England, shall we say, or being pursued by someone in England, for return, whether that be social services or even a partner, then if the person has two children that are siblings in Ireland, because of the constitutional law, there is no way that a case has ever been to our knowledge return one child and split the family, because that would have been a breach of the Constitution of Ireland. So the complexities of law are so different from what you expect to go before the court in domestic law. They're really about right to custody, constitutional laws of protection, and each country a person chooses to flee to or chooses to go would have a different set of criteria. So before anyone considers leaving the country, they really need to talk to someone like Julie. They can talk to ourselves and anyone else that is well knowledgeable legally on these situations around the world, because they need to choose which country they go to as well, because they could go to a different country and have no protection at all. It is very country dependent, isn't it, Julie?
It is, yes. It depends who the signatories are, in essence, as to what the remedies might be. And a number of countries haven't signed the Hague Convention, it's not just within Europe. It goes beyond European borders. So yes, there are certain safeguards, but you need to kind of check those over first.
We've got a change of situation. We've just I know you want to talk about it, Julie. The 1st of November 1996 Hague Convention came in, which does change things. It makes it better for parents versus parents. It seems on the documents when they're dealing with it, but it's terrifying when it's parents versus state, because the effects are very similar to a worsening situation in B2R, which is recognition of orders, really, enforcement of an English court order or something like that. With the 1996 Act, there is no longer a necessity to go through enforcement of orders in the normal way, as any foreign court now is on a comedy of courts basis willing to accept the presentation of the order or presentation of documents that would give legal rights, and they will just accept them. So the protection to a parent who is fleeing social services is greatly reduced once the 1996 Act comes fully to force in all countries. They're really in trouble. It's a much worse situation, and knowing the way the English social services function with the courts, we're dealing with corrupted documents all the time, we're dealing with fabricated documents, we're dealing with methods used by the Court of England where, in order to make sure they get that child back, a judge will issue an order after the person has left the country, and in that order they will only refer to the order that would have given them rights of custody and not produce it in foreign court. It is actually legal under the present veto foreign aid, but they do it, and non-courts allow them to do it, so that they don't have to produce the order that claims jurisdiction. Where this comes in is when someone left the country legally, they realise they've left, and then they issue the orders after they've left the jurisdiction. That does not give the Court of England rights of custody if the residence of the child has changed, which it has under certain circumstances when other people having rights of custody of the child leaving at the same time, the permanent purpose intention that actually happens. But what we're seeing more and more is the corruption of orders by the method of issuing later orders, claiming the earlier orders exist. And under the present legislation of international law, the foreign courts are accepting this evidence, even when parents, we've had a case recently, even when the parent holds before the court the actual original orders proving that this order is fabricated, they still will not look under it from that point of view, and they return the child. England don't have any rights of custody to the English jurisdiction. I don't know whether you see cases like this.
Well, I tend to deal with English cases that have an international element, and it's only recently just started really with the Slovak case. So everybody that I deal with, they're still here, with the notable exception of when I was asked to intervene in the French case, where the child was taken by Norwich and then taken straight back to France, I would say straight back, pretty much straight back. I was asked to deal with that, but it basically didn't happen for us to get involved for a variety of reasons. But the solicitors dealt with it perfectly, brilliantly, actually, thinking about it. But yeah, I mean, it's getting into the international law thing. It for me is going to be a slow thing, and it's going to be something that's going to be building up on a case-by-case basis. I mean, you and Katie are the undisputed experts in that area. I don't know of anybody else who has your depth of knowledge about it, particularly with the I've delved into. I know the Slovaks had to, because of the Slovak case, and they weren't up on the 1996 convention, as I thought perhaps they might have been, oddly enough. This was the central authority in Slovakia. I think there's a lot of misconceptions about international law, and I think that there's a lot of areas that people, even if they are experts on it, not talking about you and Katie, obviously, but there are other people who are experts, shall we say, in inverted commas, who perhaps aren't quite as expert as perhaps they could be or should be. It's just a question of keeping up with it, I think, in the way that domestic law develops. Well, international law is going to keep on developing as well.
It is. And the problem with the difference between in domestic law, you're not so legal and case law dependent as you are in international law. It's very finite in international law. So you haven't got much ground to move on to appeal to a judge and to do things that could change the case majorly. Certainly during the first part of an international law case, establishing the jurisdiction. Have a try. Lord alone, no, it's got to be the worst Skype night ever.
Kevin's coming out loud and clear. Julie's coming loud and clear. I don't know how I'm coming, but you two guys are more important.
Loud and clear.
Poor old DJ, me, I'll just sit here and listen.
I'm sorry, folks, about this. We'll try again anyway. I think I was just getting to a point. I was describing Article 13 defences on the Hague, which is basically about finding reasons that a foreign jurisdiction wouldn't return the child. Often these reasons are to do with the laws of that country, i.e. if there's a constitutional laws that give a high level of protection, like Ireland, then there might be certain factors. And to give you examples of those, the biggie in Ireland obviously is if you've got two siblings and someone is trying to return one of those siblings, there isn't a history of Ireland ever splitting a family that way and returning the child. And in most cases, in order to avoid making case law, the English social services pull out of the case before the final hearing under such circumstances. The other reason, as I've said, it's very difficult on Article 13 to say to return the child would be dangerous to the well-being of the child, etc., because the view has stretched so far over the years in case law that even domestic violence, even sexual abuse, believe it or not, is considered to be able to be managed by the other country, even when there have been allegations that the other party is a sexual abuser and this sort of thing. Children are still returned, but under the care of the state, to manage the situation in the jurisdiction they're returned to. So really, you're looking at a war zone. You're looking at claims of the child is really going to be vulnerable if returned to that country to get an Article 13 defence through really today. Article 20, which is predominantly used really, again, like Ireland, there's only a few countries you can actually fight an Article 20 case. And the Article 20 case, one of the big ones with England, because of forced adoption, and if you've got adoption before the court, and you're very close to a placement order or a placement order has been made or something in that area, then an Article 20 case could be fought. But they're very, very difficult, and they're very major cases, and often finish up in the Supreme Court of the country because of the case, the serious nature of how this would affect the Hague Convention when these kind of cases are run. They only come up really once every few years that you'll see an Article 20 case. of this nature. So we have fought those before. But what I'd like to do on Julie's side of this, to put it to Julie, because Julie sees people coming back into the country over the years after they've been abroad, and I would imagine you've picked up on some cases to see the reaction of the English courts when a child's been returned to the jurisdiction, Julie.
I can honestly say that I haven't. Sorry to disappoint you. No, I haven't.
Oh, really?
Absolutely not. No. I have been rooted in total 100% everything domestic, completely. The only thing that I can really think of is the child who was brought from Spain, but that was by force, wasn't it, by social services, and that child is in South Wales. No, I mean, honestly, I haven't. This whole international thing is completely new to me.
Right.
I think it's because we don't deal with anything private. You know, we just don't deal with any private law at all in JFF. We deal only and exclusively with public law. So you don't get arguments, you know, between parents. You know, very often the parent is a parent, and one parent has absconded or is just not interested, and that's, you know, it's sad, but that's what we tend to get. So it's no. I have to say, I can't honestly say I haven't. No, sorry.
You've not been subject to any public law cases where social services have pursued parents under the Hague Convention or B2R and recovered children, and then you finished up on the case at all, Julie?
Nope.
Right,
nope.
I'm on my own with
this.
Right. Well, it does happen, and it does happen quite a bit, more than you think. But obviously we're seeing it because we're in the international law side, and we're in any country in the world, so we see it all the time. But that's all the cases. We're not in domestic law, you see. So it does happen, and if we've got an opportunity, we can look at the case before that was perhaps in a domestic law, public law case before, or about to enter that phase when parents have left the jurisdiction. If they've approached us beforehand, no parent that's approached us beforehand has ever been returned to England, because of the fact that we make sure their legal rights are in such a situation that before we would, say you're going to disadvantage yourself, we make sure, first of all, that they really do have a clean case, that there is no one to challenge the rights of custody in any way before they leave the jurisdiction. So that's all part of the initial advice or guidance on that. And under those circumstances, because all the documents, the health is checked, whether there are any proceedings that might be argued, Section 20 voluntary care has already been argued and has been proved by affidavit of laws not to offer any rights of custody in an early case anyway. So once that's all looked at, the parents and the children are free to leave the jurisdiction legally, and that's the only situation where it's safe to leave the jurisdiction, when it is legally correct to do so. When they take up residence in a foreign jurisdiction under international law, it's imperative that they ensure they immediately assume habitual residence. And if all of the parties have left with the child who holds parental responsibility, i.e. two parents, if it's that type of situation, or even if it's guardians involved in it, then that's fine, as long as they've made a permanent purposeful intention, which is what they look for in international law, that they're not on a holiday, that they have effectively emigrated from the UK. Then it is relatively easy in law, providing this is followed carefully, to prove that the habitual residence of the child almost changed instantaneously. But that's not so if there's a party left behind, unless that party gives written permission fully and makes oath before the International Law Court to the same extent by affidavit or appearing in person that they supported this as a permanent purposeful intention to emigrate. Then the habitual residence changes immediately. If the habitual residence does not change for any reason, i.e. there's a party left behind with some rights of custody, then those rights of custody prevent the children's habitual residence changing, just by the fact they exist, and even though the mother or father is left with the children. So in that situation, that would mean that that family would not be able to assume habitual residence immediately in the foreign jurisdiction. And it would take far longer, possibly over a year, to assume habitual residence, where the court might view, if the other party had not pursued this after a period of time, that the children's habitual residence had changed. They'd effectively engaged in the jurisdiction in many, many ways, schools, health services, possibly even with the social services of the country to be evaluated. And if they've gone through all of that, then after a year, it's much safer for them in that situation. Where the problem lies is that if someone leaves the jurisdiction, does not secure habitual residence in any way that I've described, then the Court of England, if approached by another party or social services, can make an order. And they only need to be seized with an application. And that then means that the Court of England would effectively hold rights of custody. And because of the comity of the courts, that would be viewed in a very positive way by a foreign court, and this is how children are returned, either by the application being served before they leave the jurisdiction, or, after they leave the jurisdiction before they assume habitual residence, or orders, same effect on that. They're recognised under B2R in enforcement of orders, and they're recognised through the Hague, even Hague standalone cases, and result in children being returned. The problem, I'm going to say, and I'll pass back to Julie, is that in our experience, when people go back to England and they haven't voluntarily gone back, or they've left the jurisdiction, the Court of England are much harder on the parents in this situation. And we've even seen cases where completely innocent mothers, in a situation where the father is actually estranged and pleaded guilty to harming a child in a minor way, where the Court of England even sprung that around, even with the confession, to blame the mother who left the jurisdiction. And I know that sounds crazy, but it's actually happened in cases. I'm talking in profile to be careful not to reveal. And it's extremely unfair on the party that comes back in. So you've got to be aware of that. You need to seek legal advice very carefully. A good advocate like Julie, or ourselves, or anyone else who has the understanding of international law is what you need, so that you don't get in a pickle with it. But there are ways in jurisdiction of dealing with things. I know you don't do a lot of private law, you're saying public law, but in privacy proceedings, you can mediate and manage the situation to quite a degree. And sometimes fleeing can leave you in a worse situation there, Julie, can't it? Because if there is any rights of custody, i.e. contact orders, you're going to have your children returned, aren't you?
Exactly, you do need to be extremely careful. May I just pick you up on something you were saying at the start of that, once we'd all sort of got back together, about the Section 20. Section 20s are my baby in many ways. I don't know how much you know about Section 20, but if I can sort of interject here a little bit, there's a misconception that the Section 20 can come from social services, that they can impose a Section 20. What they can actually do is that they can suggest that you put your child or children into voluntary care if you don't have the correct accommodation. I think the Act is quite specific in that it talks about whether children cannot be accommodated, and I suppose that means a physical accommodation like a house, or accommodation in terms of the care that the parents would give. But interestingly, Section 20s are used as a way of social services getting the child, wrenching the child from the parents, without actually having to go to court to do it. It's quite disgusting and quite scandalous how they do this. They would say that what they'll do is they'll call the police, or they'll get the police and use a PPO. Well, a PPO, police protection order, can only be used by a constable under Section 46 of the 1989 Act if that constable believes that the child is in danger of life and limb. Otherwise, they can't actually use those powers. The police use those powers an awful lot as it happens, and people don't challenge them. Solicitors don't challenge them, and parents don't challenge them. But moving on from that, I mean, that's a whole new issue in itself. It's the Section 20 is really for a parent who is struggling, say with depression or parent in hospital or something like that, and they think, I need some respite care for my children. Let's try social services. After all, they are social services, the emphasis being on services, although they rarely provide any services these days. So the parent can use Section 20, 1989 to use as a respite care and get themselves better, or get themselves in a better position, i.e. out of bed and breakfast or refuge or whatever it might be, whatever the issue might be, and retrieve their children. What is happening in the United Kingdom and in England and Wales is that parents are rarely retrieving their children because social services are saying, you've put your children with us voluntarily. We think you might have a problem. We think the problem might be quite long-term. So we think we're going to be taking these children off you in an interim care order. So they get the care order by the back door, and they get the threshold by the back door as well. The other thing about Section 20 is that they can't say, we'll call the police or we'll take you to court, we'll do this, that and the other. If they're going to do that, you might as well keep your child with you as long as you can, because an interim care order service has to be 3 days minimum. Keep your child with you as long as you can, and not go for the Section 20, because if they're saying to you, you need a Section 20, you need to put your child in voluntary care, you need to be thinking to yourself, why are they doing this? What's in it for them? What's in it for them is, like I said, it's a free way of grabbing a child without actually having to go to court to do it. If they go to court, the onus is on them to prove their case, not you, the parent, but on social services. And what they can't do, it's illegal for them to say, we will do this, we will do that, we'll do the other. Now, they often use it when mothers, newly delivered mothers, are in hospital. They'll say, we want you to put your child under a Section 20 voluntary agreement with us, and then at some point, we'll start litigating against you. Well, the law says quite clearly that parents shouldn't go to work. Well, mothers shouldn't go to work before, I think it's 12 weeks. You can't be signed back on work by your doctor as being fit for work. So how can you be fit to make a decision about a Section 20 when you're only newly delivered 24 hours or 48 hours or whatever it is? You can't. But the point is, social services will use it as leverage to get your child. Now, there's some case law going back to Munby 2008 when he was a justice. I've forgotten the name of the case now. It's a very famous case. And he says, I can quote you the paragraph actually, it's paragraph 55 of this, that's right, yes, it was Nottingham City Council, and it was a Pathways from Care case of an 18-year-old who had given birth, and the council were ordered by Munby to give her, I think it was £20,000. The hospital was used by social services to take her child away from her for a number of hours, might have been 4 or 5 hours, but she was awarded £20,000. Now, Munby said, I think it was paragraph 55 from memory, that because she was in a vulnerable state, that social services couldn't force her in that way to put her child in a voluntary order, that they should have taken out care proceedings against her if that's what they were going to do. But they actually couldn't force her and take her child away from her. So her child was returned when she was still on the ward, still in hospital. The child was taken from her subsequently, but it was Reg, I think the baby was K and mother was G, that's right, 2008, sorry. My brain works in very strange ways, but the point about it is, if it is forced on you, if you feel you have no other option than to hand your children to social services because a threat of some sort is being made, that is illegal, and you can sue social services for that infringement on your Article 8 rights. The court takes a very dim view of it. Provided you bring the proceedings within 12 months, you're on fairly solid ground. Provided there has been coercion, you are on solid ground, and that is coercion from social services to you. Sorry, Kevin, I just wanted, because that's my baby, Section 20, one of my babies, and I wanted to explain that. I'm sorry.
I know, Julie. Obviously, you're the expert on domestic law, which is what I'm relying only on. There's a couple of points with that. You're absolutely right. The idea of Section 20, the time we came across it, we only go into the domestic law side of it when we need to, was in 2009 when social services first tried to use Section 20 as an argument for rights of custody in the Hague Convention case. I'll not name the country because I don't want to identify the case. We were on that case and we'd engaged full legal teams, SC, JC, and solicitor with the clients on that case where this Article 20 case came up for the first time. It did go to the Supreme Court of the country, and the lawyers that were on the case, they knew us anyway because we've been around for years. They asked us what the situation was in England, and one of the things we do as advocates, because it costs £8,000 to get a full draft from a barrister on this, so we would, to make sure it's worthwhile for the clients, they asked us to do the pre-draft. So we did the pre-draft on English law based on Section 20 as far as rights of custody were concerned for them. And the lawyer turned around and said, this is true. When we put it back to a barrister, then this is great on the case. And, of course, they put it back to England, and it came back the same, that there were no rights of custody whatsoever under Section 20. And rightly, as you say, Julie, the part of that is because of the way Section 20 is applied. It's almost voluntary in that they seek agreements with all parties. Social services do, where there's little signed agreements for a child to go into Section 20 care with the person who takes the care as well as the person who's parting with the child. Is that how you see it, Julie?
It's not. It is completely 100% voluntary, and the parent has full parental responsibilities. The local authority have none. The parent should really be seeing the child whenever they want to. I had one lady whose newborn baby was on. She put her baby into voluntary care. Again, she did it because she was under duress. She'd only just newly given birth. But she was having contact about 6 or 7 times a week. And not supervised, that, interestingly, because don't forget, this is a voluntary agreement. Now, Section 20, I think it's subsection 7 or 8, just off the top of my head, says that you can retrieve your child at any time that you like. You can take them back out of voluntary care and have them at home with you, or go and stay with a relative, or provided there's no reason, you can actually go abroad. You can do whatever you like with that child because you've got PR, provided there's no other court order telling you that you can't do those things. So Section 20, for me, is a real bugbear because it is being used and abused by the authorities on a very, very regular basis. And I'm horrified that it would be used in an international case. It never occurred to me that it ever would be.
If you want information, I'll exchange with you privately on that in more detail, Julie, to see exactly how it was done.
Yeah, lovely.
What I want to say, to add to what you're saying a little bit, and it amplifies what you're saying, is people don't understand that under the 1989 Children's Act and the 2002 Adoption Act, I can't remember the full name of the Adoption Act, the combination of the two, but it's mainly the Children's Act 1989, once a local authority even takes a child or is given a child under voluntary care, it could be a parent who's having chemotherapy, like we talked of in cancer. It has happened, I know the case, and they can't have the child with them, and they ask social services to help. They think they're being protected. But after 24 hours in care, it is law that they have to then consider that child for forced adoption, full stop. And this is where social services ask for changes at that point, because they're under, they almost immediately head towards the twin tracking system, where there are 2 options for that child once the 24 hours has passed. I was amplifying your concerns over the use of Section 20.
That's right, yes.
Technically, it leaves you believing you can request the child back at any time because it is a voluntary care situation.
Yeah,
but of course, you know what happens once the parent makes the request, and they have to They can't just go and grab the child technically. They have to notify normally on that, and then they get the child back. Once they notify, immediately social services may choose to use police powers, and they may choose to use the power of the courts to get an emergency order, an ECO, to actually take that child then on grounds they've built up in the time that the child's been in voluntary care, because the child, after 24 hours, the point I was making, has to be considered under English law for adoption. It's just part of that. I don't know if you've come across that view. I'm presuming you have. If not, I can let you have a draft of that.
I haven't. May I just correct you on one minor point, though? You actually don't have to notify them. All you have to do, and the Act says that you can actually go and take them from the, where is it? It says, the local authority may not provide accommodation under this section if any child or any person who has parental responsibility for him is willing and able to provide accommodation. It doesn't actually say that you have to notify the local authority. So, for example, if your child is living with a foster carer and you're having, I don't know, you're going to the local park and you're, with a social worker maybe sometimes, and, you can actually take the child away there and then. You don't have to notify them.
I think...
It says any person who has...
Yeah.
It says any person
I think
who has
you're actually right, Julie, in what you're saying. And
you don't actually have to notify anybody. You can just take the. I know one parent did it in Contact, and actually said, "Well, I'm using section 20, subsection 8. It says any person who has parental responsibility for the child may at any time remove the child from accommodation provided by or on behalf of the local authority under this section." And they actually wrote that bit down and showed it to the contact worker, and the contact worker says, "I don't know, I'm not sure." And they said, "Well, look, read this." And the contact worker read it, and then rang the social worker. And the social worker said, "Try and keep them there." So the contact worker blocks the door, which is trespass to the person. It's false imprisonment of the children and the parents at this point. Blocked the door for 45 minutes whilst they called the police and the social services. It is absolutely outrageous. Absolutely outrageous. And you don't actually have to notify anyone. You can just get them from the accommodation. So strictly speaking, from the accommodation could be the contact centre or wherever you're meeting your child for contact, or it could actually be in your home but throwing the social worker out, couldn't it? Or it could actually be from the foster carer or the care home. They are supposed to tell you where your child is living, so you can invoke your rights under Section 20, subsection 8, to remove that child from the accommodation. There we go.
Yeah, I think I'd have to look back at the particular case concern. It may be that in some way this was worked into these voluntary agreements, because the way social services work, it isn't even in line with the way they're supposed to work as well in these cases. The way they get these agreements made is most unethical at times, because it's very typical of social services to try and seek more than they're supposed to in the circumstances, if you know what I mean, Julie. And that. But the element of the 24 hours, that came up in a case in 2009, which was actually a Hague Convention Article 20 case. And in that case, we had to do an affidavit on the English law side of that regarding this exact process of how the twin tracking worked and everything that was around that case at the time. And as part of that draft against English law, this element came up and was staggering when we first discovered it, that they didn't have a choice. It was must was the word. Now, I'll let you have a draft of that after the show from that affidavit, because you will realise that you have a stronger argument than you think as to why social services are doing this, if it's a must under English law, and the term is must.
Sure, absolutely.
Consider that child for forced for adoption, Little wonder we're losing so many children through voluntary care. Can you see they're actually being targeted in law that way?
Of course, yeah. And like I say, it's an easy way for social workers to go and meet these adoption targets, isn't it? If they don't actually have to litigate. But I've known cases where children have been on Section 20 agreements between parents and social services for years, not just for weeks, which is, I think, was the intention of Parliament, but for actually years. And it's just absolutely dreadful. In fact, in one case, the one where I told you where they took the children out of the contact centre, they sent the police round, and the police took the children under a PPO. So they were at the parents for 2.5 hours, and the children were having a bath with mum and dad. Not with mum and dad, but mum and dad were bathing the kids. And the police came to the door, and 2.5 hours later, after talking to the police, the children were then let out by the parents, and social services went for an interim care order. After these kids have been on, I think they've been on the voluntary Section 20 for about 9 months at this point. And the magistrate said, I quote, that it took the parents, he said it took these parents to take the children out of a voluntary agreement for you to get your heads out of your backside. And that is what the magistrate said. And the parents' barrister had to do a double take. The magistrate was absolutely livid. He didn't feel that the children should have been on Section 20 for 9 months. And it is ridiculous. And the parents only had 2 contacts a week and only saw them sort of an hour and a half to 2 hours on each occasion. It was ridiculous. Well, what can I say? I mean, social workers just feel that, the law is for them to decide upon and not for parents to have any rights with. It's really sad.
There's another area you mentioned in contact that might be of an interest on this, which we didn't cover on the earlier show, Julie. And this is where the contact centres now are changing in the way they're being financed, i.e. social services are dropping out of the finance of it, and local authorities, etc. The state side's dropping out, and the bill is now going to the parent who wants to use the access centre for contact. They don't have any choice if that's the arrangement of the court. But we've seen bills of several £100s to just have a 2-hour contact, Julie. It seems staggering that this amount of money is being charged to the estranged parent to have contact with their children.
Yes, and very often where parents are working, the parents have to put at least a large part of that bill as well. So if you're a working parent and you've got your child in care and you go to contact, you're going to have to pay a couple of £100 every single time you see your child. I've had that as well. I'm not joking.
Yes, I know. And if you think about it,
belief, it really does.
I know. I've got one specific case, which is the amount of money involved in that was well over £200 an hour it worked out at. But because of the way it equates, there's no fixed price for all this. They seem to be able to charge what they like, and it can be £100 an hour, or it can be 200 or more an hour. There is no regulation of this, Julie, is there?
No, there isn't. And certainly, if contact centres ought to be, fully regulated in their own right if it's going to be a business. But I think possibly Brian Jerish might have something interesting to say on contact centres, because he seems to, from what I remember at the conference that he spoke at, he was saying something about Kafkas owning them all. No, Sure Start might have been Sure, can't remember now, but it was one organisation owning virtually all the contact centres, and how the money is organised. He's got a lot of data on it, so if you want to talk about contact centres and contact, then he's the guy to talk to, I think. Most contact centres, from what I've come across, are absolutely diabolical places that no ordinary parent would normally take their kid into.
Well, I know. I mean,
lack of toys and lack of...
Yeah. We'll raise this with Brian next time he comes on the show, now you raise this point, because I think I remember him going in this direction. But this is a further proof of the gravy train, that this is about money behind the scenes and people making a lot of money around child proceedings, and that money, some of it's coming from the state and some of it's coming from parents. They're paying vast amounts of money into this system, and it is about money. The whole thing's about money, Julie.
Of course it is. It's absolutely disgusting. It's people being bought and sold, and it shouldn't be happening. I mean, contact centres, I mean, whoever thought that anyone would be getting rich on contact centres? I don't know if it's something that, I mean, contact, for goodness sake. I mean, the whole issue of children and contact centres and having contact with their parents, can't we just make language a bit more normal? We use this in an argument against the placement order of which a 10-year-old child was put on a placement order, and part of the argument was, that this child was talking about having contact with her family and going to the contact centre rather than having a lovely visit with granny or a lovely visit with mum and going out on a visit or going out to this, that, or the other place. She was going to the contact centre and talking about foster carers and social workers. Her language was completely and utterly socialised by the situation that she was in. It is very, very sad. We have made a rod for our own backs with all of this. I think you can all guess what I'd be doing if I were in charge.
Yeah, we've only got until about another 2.5 minutes left. But the point, I mean, when I interviewed John Hemming last time, I think he made this point around the financial side of it was within that interview, and the other argument he was making was that the main point of his bill that he tried on the 26th to do something was to get better transparency, wasn't it? Within about 2 minutes. But what I would say is if the transparency was there and that people could see all this financial gain being made from state and from the individuals, they would have been the most annoyed that their tax money was going in this direction, wouldn't they? They
would. I think we just need to, the awareness week is key to sort of helping get this out there on the week of the 10th of December to the 15th of December. We just need to get everything out there and tell everybody exactly what is going on, because it's all being done in their name, in our citizens' names, but our citizens don't know what is happening. And I think we need to make people aware of what is happening. Eventually, I'd like to have a straw poll conducted right across England and Wales. I tried to do this before, but getting volunteers is extremely difficult. But to be able to do that would be wonderful. To ask people if they know what adoption is and what it involves, what the care system involves. I think the care system's got a pretty bad reputation, to be perfectly frank. But at the end of the day, I mean, we just need to make people aware. We need to let people know what's going. Shout it from the rooftops, whatever. Just find ways, creative ways of letting people know what's going on.
Right, I agree with you. This is what we're doing with the radio side, is to try and get it out. Brian Garish is trying to do things with the TV side of this and the radio side. And I know yourself and John and everyone in your camp are trying to get this out any way you can, including Christopher Booker and everyone else involved in this. And this is what we've got to do, Julie, isn't it? We've got to get the reality and the facts out there whilst trying to remain legal at the same time.
It took Hillsborough 23 years. God forbid it takes us that long.
Now, Paul, the manager of the radio station, has given us an extra 10 minutes airtime till 5 to try and help us with the Skype issues, if you're okay with this, Julie. So we can sort of ramble on a little bit longer. Seems we've got communications now working on the radio. Thank you, Paul.
Kevin, can I remind you, for some reason, although I heard that from Paul, there's two problems. 9 o'clock is only 5 minutes after 5:02, and we're not on air anymore for some strange reason, even though you're connected, which means we are on air. So it's a bit confusing.
Have you done a test on the... can you just do an air test on Critical Mass Radio?
Everything.
Can you do a air test on Critical Mass Radio? Just see if we're going out, in case we've got an issue on...
Nobody can hear us at the moment.
There was an issue with Blog Talk yesterday, where Blog Talk did not go out for a period of time live, but the archives appeared. I picked up that yesterday, Andy, and I'm wondering if we've got the same issue on this one or not. It's dropped out during the show. Are you getting the audio?
Also, I'm on the phone to my telecoms provider, and they tell me there was a major incident in Lincoln. so that was
maybe
probably
it's
the
flooding,
real...
Andy.
Sorry?
Yeah.
Maybe we've got massive flooding issues here.
It is flooded, and Paul confirms we're still live.
I'm going to thank you at this point in case we lose the Skype or anything else happens before the end of the show, because it's been a traumatic night. But, I do thank you, Julie, for coming on, because it gives us an opportunity to delve into things a little bit. And we're going to have to do this again, Julie, possibly when we've got Skype functioning during the entire show would help, and go a bit more in depth, because you haven't really had enough time on yourself. I've had to ramble away for a while, so I hope you can avail yourself at another date in the future when we can get you back on for that.
I'm sure, yes.
That's tremendous, Julie. Now, what I was going to do was really hand it over to you for the remainder of the time to possibly explain what your camp's doing with John. What have you got on the agenda for everyone to follow on to in the next coming weeks and months?
Okay. The main thing is the Awareness Week. As I say, that starts, I think it's on the Monday the 10th to the December the 15th. December being in Birmingham at the Birmingham Midland Institute, which is a really lovely venue, actually. Plenty of different rooms, and there's a cafe downstairs. It's very comfortable. It's very central. And that's for a conference. Now, it's a conference with a bit of a difference in that we've got Denise Robertson from the This Morning programme, who is going to be partially chairing and also speaking. And she's absolutely lovely. I've had quite a long conversation with her on the phone, and she's very down to earth. She's really nice, despite me being terribly nervous about talking to her. She's absolutely lovely, and she's got some very interesting takes that I want people to hear. Very interesting things to say. I was really rather stunned, and I thought, I hadn't quite looked at it quite like that. We've also got Christopher Booker. He's been doing loads to get everything out there and aware, and he's going to be talking, looking at things from his angle. Not sure what particular angle he's going to take, whether he's going to look at it from a historical point of view or the stories that he's been involved with, the outrageous things. I don't know, but that'll be up to him. We've also hopefully got somebody to confirm from the Island Report, because psychological assessments are the death knell of a parent's parenting ability, basically. So to explain what to look for in your sort of psychological assessments. We've also got Jackie Courtnidge talking about post-adoption contact, because it's a bone of contention, and it is widely recognised that children who have contact with their biological family fare rather better in adoption than those who are completely cut loose and forced to live in under an assumed identity, if you like. And also we've obviously got John Hemming speaking, and we've also got Ian Joseph is coming over from Monaco, which is terribly good of him. You know, it's wonderful, really, of all these people to take part. But he's got the farthest to come. France, actually, nowadays, he lives, and he's coming over. And he's got loads to say. I'm absolutely certain that he's going to be very entertaining as well. I'm just trying to think if I've forgotten any. Oh, yes, Paul Whitehead from Our Futures. He's an adoptive parent, and he's going to be looking at the pitfalls of being an adoptive parent and how, what you're not told by social services, I suppose. You're not given the child's full history or whatever, and he's going to be dealing with that. There will be questions that will be allowed to be asked by attendants, conferencee attendants. Basically, the questions will have to be in writing. Otherwise, the whole thing could descend into chaos. Or you could get the same people who are so keen that they just want to ask lots and lots and lots of different questions and start bringing up their own cases and various things like that. We need to have questions to be written. And then if they want to ask a supplementary question, I think that depending on the answer, then they could be allowed that as well. But we want to be able to get lots of different people from the hall being able to have an opportunity to talk to these really wonderful, what can I say, absolutely amazing people, and their experiences that they've had, to get the information out. I want people to go away with really useful things. At these conferences, they always do go away with really useful things. I mean, Skegness conference, the other conference in Birmingham, and there was a Stoke one run by UK Column. Really, really useful stuff. Well, I don't want this to be an exception. I want them to go away with really useful stuff that they can use and act on. So basically, I mean, it's going to be starting at 10, and each speaker will have sort of half an hour to sort of 40 minutes, and then there will be questions, and then possibly a little bit of a break, and then we'll all sort of come back. But what we can't do is have people, lots of talking going on inside the hall. I think we need to be respectful of these speakers. They've come a hell of a long way, for starters. Denise is coming from Newcastle, and Ian's coming from France, and Christopher Booker's going to be driving up from somewhere south of Bristol. So we need to be very respectful of these people. I think people have a chance to talk to them in the breaks and at lunchtime and possibly at the end anyway. So it's going to be a way of disseminating information, getting it out there. Whether or not any press will be there, I really don't know. Possibly someone from Midlands area. But the rest of the week prior to that, is going to be punctuated with hopefully a press briefing at Parliament. Hopefully I've got a concert organised by a Russian pianist whose son is in care, and he's taking this course on really fully, and he's an absolutely superb pianist. I'm hoping I'm going to be able to get to turn pages for him. He's playing some Rachmaninoff and Chopin and stuff like that. Absolutely gorgeous, amazing stuff. So hopefully we'll have that in some time in the week before the Saturday, and also various people giving interviews to radio and television, and it's really just about getting it out there and getting awareness, basically. So that's basically what I've never organised a conference in my life, I have to say. I'm really nervous, really nervous. And possibly only 6 will attend. I'm really, I don't know. We'll have to see. Hopefully it'll be a bit more than 6. But no, I won't be doing any talking at all, so you won't have to listen to me.
Julie, we're up to time. We're just going over it, actually. So we're going to have to end the show at this point. But thank you very much for coming on, Julie.
Thank you.
And we're going to definitely get you back on again, I can assure you, so we can do this again, because we've got to keep this information flowing.
Of course, yeah. Thank you very much.
Thanks, Julie. Thank you.
So, bye-bye.
Bye. That was the Earth Needs Rebels with Andy Peter and Kevin Bull.
You're listening to Critical Mass Radio. Now it's our turn.